Good afternoon, everyone. I'm Andrew McKeown, a practicing barrister and case reporter with Irish Legal News. And on behalf of Irish Legal News, I'd like to welcome you all to today's event. This is our very first webinar, and we look forward to facilitating this discussion about access to justice under the new government. So I'll call on each of our guests in turn to say a few words, some remarks, and then there'll be a Q&A at the end of the session. But you'll all be able throughout the session to type in your questions, which can be asked then at the end. So our first guest that I'd like to invite to speak is Eilis Barry. She's the Chief Executive of FLAC, the Free Legal Advice Centres. And prior to joining FLAC, she practiced as a barrister, specialising in all aspects of employment law, anti-discrimination and equality. So I'd like to invite Eilis to speak first. Thanks very much.
Thank you very much. I want to congratulate and thank Irish Legal News for having access to justice as the theme of their first webinar. In FLAC's experience, it's incredibly difficult to get access to justice onto any agenda, and it's even harder to get real change in the area. And I hope that the great interest which is shown in this webinar is an indication of the desire for real change. So thanks and congratulations to Irish Legal News. The phrase access to justice is open to many interpretations. In FLAC's view, it encompasses a number of things. First of all, legal information, legal advocacy, early legal advice, legal aid or representation. But it encompasses more than that. It also encompasses access to the courts, where procedural barriers and formalistic rules can constitute real barriers. And I've no doubt that Wendy will be talking about the practice direction into immigration. And I just want to add that FLAC wrote to the former President of the High Court and also the Superior Court Rules Committee to express our concern at the inordinate barriers that were being put on the shoulders of the lawyers and the clients in immigration cases. I also just, by the way, want to congratulate Wendy on her great victory for the Chilean student. It was a gobsmacking case when you read about it, so very, very well done. Okay, I think it's worth just remembering briefly why access to justice is so important. To FLAC, it's an essential part of democracy. There's no point in enacting laws or introducing beneficial provisions if people don't know about them, or if they do know about them, that they can't enforce them. We very recently in FLAC launched a benefit take-up campaign in relation to the rent subsidy. During COVID-19, the criteria for rent subsidy were broadened, but there was actually very little news about it, and as a result, very few people accessed it or applied for it in very urgent situations. So we've launched a campaign to try and make people aware of it and to try and get people to apply for it and look for arrears. Access to justice is also about social inclusion. In FLAC, we take on a small number of cases with a particular emphasis on vulnerable and disadvantaged groups and individuals. And we run a clinic for the Roma community. And what is very clear to us is that the greater the need there is, the greater the number of justiciable issues that you'll encounter with one particular client and their family in areas like access to emergency housing or getting on the housing list or getting emergency payments, or issues like debt or rent evictions or whatever. And solving one problem can have an almost disproportionate beneficial impact on other areas. We also believe that access to justice improves social inclusion, and there's been recent research in Scotland that shows that access to justice improves health outcomes, which isn't really surprising when you think of the levels of stress your clients are under. In other jurisdictions, access to justice is given the same prominence as access to health and access to education. And we in FLAC have argued for it to be given the same equivalent prominence in all policy. We want it stitched into all national action plans, and we would have liked it to have been stitched into the programme for government, but it isn't there explicitly. So prior to the general election, we ran a Right to Justice election campaign where we were asking candidates to sign a pledge which would commit them to look for a root and branch review of the legal aid system if they were elected, and also to accept that a properly functioning and accessible court system is a core part of access to justice. Now, a good number of the candidates signed up to that. Now, I have no doubt that Keith will be talking about the need for a properly functioning family court system, and with Keith and along with a number of other NGOs and the Bar Council, we took part in the Courting Disaster campaign, arguing for the properly functioning family court to be built in Hammond Lane. And we're really pleased at the very recent news that this is now going ahead. But obviously, this is just Dublin. That needs to be mirrored all around the country. And I think the commitment in the programme for government in relation to court reform has to extend beyond Dublin. So I think it's worth just reminding ourselves, why do we want a review of the legal aid system? Why is it so important? Essentially, the system we have now is the interim system that was recommended by Pringle and FLAC over 40 years ago, when Ireland was taken to the European Court of Human Rights by Josie Airy and found to be in breach of her rights under the Convention by failing to provide her with legal aid. So effectively, we still have that interim system. We've never had a comprehensive scheme. And that's why we're arguing for it to be changed 40 years on. Legal aid isn't free, despite a really narrow means test. You have to pay what may be a pretty hefty financial contribution. The Legal Aid Board has no leeway if you don't meet the very strict means test, no matter how complex your case may be. There are very significant delays in some law centres, up to 6 months or up to 9 months. And frankly, we in FLAC dread what's going to happen post-COVID. We anticipate that the delays will be greatly increased. There's also very significant exceptions. Again, no matter how difficult or complex your issue is, you won't get legal aid for a claim before the Workplace Relations Commission, either under the Equal Status Act or in any type of employment case. Again, no matter how little resources you have, no matter how little capacity you may feel you have, no matter how sensitive the issue is, and no matter how big the resources your potential opponent may have. For example, you won't get legal aid in a claim of sexual harassment against your employer. You won't get legal aid in a claim in relation to a child with disabilities looking for reasonable accommodation for a school. There's also a perception that legal aid isn't available in housing cases, and for the most part, the Legal Aid Board doesn't provide representation in housing cases, but it's our understanding that people can and should be able to get legal aid from in terms of housing cases, but it doesn't really happen at the moment. And there's no legal aid for social welfare appeals, even though they may involve complex EU points and people may be facing destitution if they don't succeed in their appeal. We've been calling for a root and branch review for some time, and we're not alone. The Bar Council have joined that call, the Law Society have joined that call, and the Joint Oireachtas Committee on Justice and Equality, when it considered its review of the family law system, it also made that recommendation last year. And the Chief Justice had made numerous calls for broader and deeper legal aid. And the UN Human Rights Committee, when it was monitoring Ireland's compliance with the third convention, also made recommendations about extending legal aid for social welfare and cases before the WRC. With the COVID crisis, FLAC has experienced an unprecedented level of queries to our phone line. Now, we anticipated that they would occur in family law, but for the first time at the end of May, employment queries exceeded family law queries to the phone line. And since lockdown, we've had a huge number of people contacting us. We know from the last recession that people will be losing their jobs, and that on foot of losing their jobs, inevitably sometime later, there will be debt problems, there will be problems with rent arrears, there will be problems with mortgage arrears, there will be problems with evictions, and there will be problems with repossessions. And it's not clear how many of these issues the Legal Aid Board will be able to deal with. And we're worried about what happens when the pandemic payment stops, when the payment break stops, when the prohibition on rent increases and evictions stop. We had a reasonably positive response to our general election pledge, but I suppose we're somewhat disappointed in the programme for government that has emerged. The programme for government is quite general and not non-specific, and while we're pleased with some of the measures, it doesn't contain an explicit commitment to reviewing civil legal aid, though there is still room under the programme for such a review to take place. We broadly welcome many of the policy initiatives, in particular the recognition for the need for anti-poverty measures, and the recognition that there are structural inequalities which leave those who are poor at highest risk. We also welcome the commitment to a new social contract, but again we would argue that access to legal aid and access to justice is fundamental to such a new social contract. We're also concerned about the system of supplementary welfare allowance. It was set up to provide a safety net beyond which people wouldn't fall through. But again, from FLAC's clientele, we regularly see people who have no access to any form of social welfare. And again, we believe that a safety net is a key part of the social contract and hope that it will be developed with the new government and as part of the new social contract. We also welcome the end to the inhumane system of direct provision, and I suspect your other speakers will be speaking about that too. But we believe that close attention has to be paid to what is replaced, and the devil will be in the detail. What will people's entitlement be to social welfare? What will be their entitlement to work? Will they be able to live in their own homes? What is the position in terms of who's providing for the provision for people in such circumstances, and will the application process be speeded up? There's no particular reference to employment rights in the programme for government, and it has been FLAC's very recent experience that this is an area that needs to be looked at. The whole infrastructure around employment rights needs to be looked at. There's a whole lot of queries around people being asked who are around the system in terms of layoffs and whether people are genuinely been laid off and will they be made redundant. There's queries around the rights of people who do not want to go back to work, who feel that their health and safety will not be properly catered for, or people who can't go back to work because there hasn't been sufficient childminding put in place. But what is very clear is the need for information, advocacy and legal aid in the whole area of employment law. We also welcome the commitment to making provision for people in debt, but the reality is FLAC has been making recommendations in this regard since the last recession, which haven't been implemented. And it's really critical that the whole body of recommendations that are there in terms of reform of the personal insolvency legislation are now implemented. We will have a whole new cohort of people coming down the road who will be seriously in debt. At the moment, there's over 26,000 people from the last recession who are still in long-term mortgage arrears. So they're going to be met by a new cohort of people in debt, unfortunately. And we believe that there's a real need for a strong consumer voice. And I suppose we question whether that lies properly with the central bank, given its other roles in terms of protecting the economy. And we're also calling for a proper mortgage to rent scheme and a reinstatement of the mortgage interest subsidy. And we believe that it's time now to look at a new code of conduct which would deal with old arrears, new arrears, and people who have unsecured debts, such as people who have very substantial rent arrears. In terms of equality in relation to travellers, we very much welcome the provisions in relation to accommodation, but it's absolutely vital that the recommendations of the Traveller Accommodation Expert Review are implemented. While we also welcome the commitment in terms of hate crime, again, the devil will be in the detail. And we've also argued all along that there needs to be a complementary system of remedies for hate speech, because at the moment there is no proper remedy for hate speech, and that should happen in tandem with the overdue review of the incitement to hatred legislation. And we're also calling for, and we see this from the cases that come to us from the Roma community and the traveller community, for there to be a remedy for racial profiling. At the moment, there isn't a proper civil remedy for racial profiling. And again, the equality legislation needs to be looked at to ensure that the prohibition of discrimination properly brings within its remit the functions of the guards and the immigration services. So while we welcome the provisions, the broad provisions in terms of equality and social inclusion and other such matters, we do believe that the devil is in the detail, and we look forward to working for a modern, inclusive society. Thank you.
Thanks very much, Eilis. Our next guest is Jim McGowan, who is an experienced criminal barrister and the outgoing chair of ICBA, the Irish Criminal Bar Association, which is a representative body for all barristers who practice in the criminal courts.
Thanks, Andrew, and thanks to Conor and Andrew for extending the invitation and to featuring criminal law. Oftentimes we don't find ourselves in the same room as Keith, Wendy and Eilis, but we have many shared issues that hopefully we can borrow from each other. There are a number of issues that I'm sure I could rant and rave about, and hopefully I'll put some structure on my rantings this afternoon. The first issue that arises time and time again when it comes to access to justice for criminal matters really arises before matters ever come to court. And by that I mean in the pre-trial stage, in the investigation stage, and really in the general detention of individuals and the retention of evidence at the very early stages. By the time it comes to court, there is an element of batting out fires, trying to fix situations that may have already arisen. And to that end, when one looks at the criminal justice system, I don't think you can examine the criminal courts or criminal lawyers without also shining a light on An Garda Síochána and the resources or lack thereof that they have. To start with that kind of vein, one of the disappointing features I think Eilis already referred to was the programme for government that was produced not too long ago. And when one looks at the reform for courts, there is little to no mention of the criminal courts or the criminal trial process at all. In fact, the height of their intention is to review whether or not a public defender system should be made available. And I'll come to how disastrous that would be in due course. But there are significant recommendations made in respect of An Garda Síochána, and with the greatest of respect to the intentions of the drafters of the programme for government, they are largely, I'm trying to say this quite respectfully, useless or pointless. They adopt a number of features that have been commended in the policing authorities' reports, and they are excellent in theory. However, that report has been published for some time, and the most important recommendation, in my view, is in effect that the police get back to policing business rather than the administrative tasks that they're often faced with. The most fundamental example of this that I can give you relates to the interview and detention of a suspect, where a guard and a colleague will attend the interview. One will put questions to the suspect in question, and the other will commit every answer and every question to writing, which ultimately stalls the process, interrupts the flow of the interrogation or the investigation, and moreover, extends detention periods for suspects longer than are necessary. With the benefit of the electronic recording regulations and other recording mechanisms that are available, that can very easily be done away with. And indeed, a transcript of the interview can be given and can be procured by support staff that should be there to assist An Garda Síochána. So that is one of the most draconian measures that I can think of that we are still stuck in the dark ages with. And those type of practical matters, in my mind, haven't been properly addressed by the programme for government. There are grand promises that are contained within However, I think it's a more root and branch approach that needs to be taken with regard to An Garda Síochána reform. Because then when it comes to court and disclosure of information and disclosure of evidence is given, issues arise in how that evidence was procured and how it was preserved. And oftentimes, and we've seen from our partners and our neighbouring jurisdiction in the United Kingdom, the difficulties they've had with disclosure, and indeed how their criminal trial process grinded to a halt, and rape trials and white collar crimes in difficult cases collapsed as a result. The second rant in my criminal trial process and access to justice arises from this disclosure issue. In response to the difficulties in England and on foot of the recommendations in a Law Reform Commission report in 2014, the government attempted to put its mind to the issue of disclosure, to codify it, to put the obligations on statutory footing. Unfortunately, what we received was a single section amending the disclosure of counselling records in respect of sexual offences alone. And rather than seeking to overhaul or indeed codify the general disclosure obligations that are warranted and that are necessary, both for the guards to understand the remit of their powers and their obligations, and then for the prosecution and defence to be in a position to deal with the disclosure at trial, we were met with this single section. If any of you have had the opportunity to look at Section 19A applications, and this is 19A of the Criminal Evidence Act 1992, many of you may feel that it is somewhat lackluster, and it is poorly drafted in the extreme. For example, and just to give you some highlights as to the frailties of this section, it relates to sexual offence proceedings, but only sexual offence proceedings that come before the circuit court or the central criminal court. And by definition, that automatically excludes either the special criminal court, but more importantly, the district court, where we know more serious offences are coming before those courts, they're being dealt with, and indeed it appears that a judge cannot order, pursuant to Section 19A, any counselling records. And it would seem to be somewhat of a silly distinction to make. It doesn't appear to serve any purpose save to actually avoid disclosure obligations, and I think that that will obviously be ripe for challenge when a factual scenario meets that case. Moreover, there are some positives that have arisen from 19A. One is that complainants in the instant case will get representation, and they, similar to the cross-examination of complainants in a criminal trial relating to their previous sexual history, will be afforded a legal aid certificate to cover counsel and a solicitor, and the law centres generally organise that. And that is a positive. That means that there's representation for the non-traditional parties in a criminal trial, where we ordinarily think the prosecutors and defenders and the judge and jury, that now complainants are starting to be more recognised, and indeed there is precedence there for representation for complainants. So that is something that is a positive and seems to have a degree of spotlight, and indeed paving the way so that complainants may in the future gain further representation for other matters as well, we would hope. I think, like Eilis has already referred to, and I've no doubt my colleagues will as well, the COVID-19 crisis certainly brought certain matters to the fore for us. And as many of you will know, the criminal trial process largely grinded to a halt quite suddenly, where ongoing trials that had impaneled juries, they continued to conclusion, but nothing further was done. And clearly that caused a level of stress for defendants who are in custody, where their trials couldn't continue. And the courts have endeavoured to address this with priority hearing dates, setting dates in September outside of the traditional legal terms. And I have to say the uptake by practitioners has been overwhelmingly positive, where everyone is anxious to get back to work, but more more importantly, I suppose, to facilitate that access to the courts for defendants and victims alike. But one thing that became glaringly obvious to all of us was the inadequacy of our facilities, that there were matters that were dealt with by way of video link, such as High Court bail applications and certain sentence matters and mention matters. And unfortunately, from time to time, technology failed us. Like everyone, the pandemic effectively came out of nowhere and we hadn't properly prepared for it. But the prison services are to be commended for their role in facilitating the online consultations, the video link consultations, and then the video link court appearances. However, a lot has to be said for the fact that more provisions like that ought to be made available. So prison visits remotely, either for practitioners or indeed for family members of individuals in custody. And that is something that falls, in my view, within access to justice in the grander sense of things. And moreover, the disposal of certain matters by way of video link or remote hearing where possible, and where people are in a position not to clog up court lists or court time. I understand that there was a significant media coverage at one point where there was confusion as to whether or not barristers in the Bar Council and ICBA were clamouring for virtual trials or juries to be dispensed of, and that simply isn't the case. I think you'll struggle to find a criminal practitioner, either a solicitor or barrister, who would ever forego the adversarial system with your jury in court, where that jury is in a position to hear the evidence in real time and, more importantly, gauge the behaviour and the overall demeanour of a witness or the other players in court. So that is something that is at the far realm of any prospect or any proposal from the criminal bar, and we are looking forward to getting back to our traditional trials as soon as possible. The next bugbear of mine when it comes to access to justice is something that has come to the fore in recent years about the legal profession itself, and whether or not there is a necessity to have an independent referral bar, or whether or not, as the LSRA suggests, we can become a unified profession. I won't dream to speak for my family law colleagues on the call, or indeed my other colleagues that are in civil practice, but I can certainly say without any fear or favour that that would be a deplorable decision in my view if we were to unify the professions, particularly from the aspect of a criminal trial. The criminal trial, as many of you know, has so many layers and levels and intricacies to it that barristers and solicitors play very distinct and important roles in the criminal trial process. But speaking as a barrister and as a member of that independent referral bar, where one is able to prosecute and defend and without having to pledge oneself to either side, I think that that can only result in a fairer, more well-rounded prosecution or defence, and ultimately a fairer trial. The public defender system has been mooted and floated over the past decade or so from time to time. And I think one needs only look at the American system and the public defender system in particular, of how underfunded it is, how overburdened it is, and indeed how the lack of expertise in those areas has caused a significant amount of miscarriages of justice. And all things being equal, I believe that justice is better served when the accused, and indeed when the complainants and the prosecution more generally, are represented with a full legal team, with a full expansion of skills of solicitors and barristers. So with that little plug in mind, I'll leave off my gripe about the LSRA attempting to abolish us and unify us as solicitors. There is a number of matters that the government, has failed to deliver upon, certain matters that they shall deliver upon. And one of the most interesting, and one that I see becoming a particular issue as criminal trials progress and as more knowledge about this is realised is an EU directive that is one of 3 effectively brought in to protect the rights of individuals in criminal proceedings. And this directive was passed in 2012, and it's the right to information in criminal proceedings. And many of you may be aware of the right to interpretation and translation in criminal proceedings and the right of access to a lawyer. It is my view, and indeed a view shared by many colleagues, that this directive has direct effect. And what this directive serves to do is quite remarkable. In essence, it translates that individuals who are suspects ought to be informed of their status as suspects even prior to arrest, and that a degree of information ought to be communicated to them. But moreover, when one is ultimately apprehended and arrested in the Garda station, there are significant provisions contained within the directive that one shall have access to the case file. Now, many solicitors will speak to you and tell you that that simply is not the case in our jurisdiction, that ordinarily solicitors attend at the Garda station, and if their client is being interviewed, they're told in very bold terms the scope of the charge or the allegation, but they rarely, if ever, receive any documentation or substantive information. Indeed, much of what they learn is throughout the interview itself and the questions that the guards ask. But Article 7 of that directive grants the suspect or the accused full, unrestricted and free access to all material evidence in the possession of the competent authorities. Now that, in its term, would include documents, photographs and audio and video recordings such as CCTV. So in essence, if we gave proper weight to the directive, which is in, as far as I'm concerned and my colleagues, with direct effect, one would be better armed with knowing largely the case against you and the evidence against you. A solicitor would be better able to advise the individual if they have been arrested, and ultimately an awful lot more would be available to the defendant, or I should say the suspect or arrested person at that point in time. So that is something that will significantly impact the general theme of access to justice, and more, I suppose, condensed from my point of view, access to justice in the criminal system. It is a provision that's there. The directive is in. Obviously, member states are given a deference, a degree of appreciation as to how they shall transpose that, and we are waiting on guidelines or indeed any purported statute that would seek to put that in and enact it in Ireland, but that awaits to be seen. But it is a significant failing on the government, and it is one that has been effective for a number of years. By my calculation, it's the 2nd of June 2014, which was when member states were to bring into force laws and regulations to comply with the directive. So it remains to be seen. Certainly, I can see many challenges arising in the near future in respect of serious crimes, things like white-collar crime, gangland crime. They seem to be primed for challenge in this regard. So Andrew, I'm sure I've prattled on long enough, and as much as my intention was to put structure on my rantings, I'm not sure I've accomplished that with any great success. However, thanks so much, and I'll answer any questions in due course.
Great, thanks very much, Jane. With that, I'd just like to remind all attendees that they can submit questions using the Q&A button, which I can put to the panelists at the end. So our next guest is Keith Walsh, who is a solicitor and mediator who heads up Keith Walsh Solicitors, which is an award-winning family law firm in Dublin, and he is a past chairman of the Law Society's Child and Family Law Committee. Thanks, Keith.
Thanks very much, Andrew. It's not easy to follow the previous two speakers, and I suppose I'm just going to deal with family law and access to justice problems, some of which are common to the previous speakers and their areas as well. I suppose I might just first of all look at the issues that are peculiar to COVID-19, and some of them are exclusive to COVID-19 problems, and some actually are not exclusive to it. I suppose one of the highlights of access to justice, or difficulties with access to justice, that arose during COVID was people's physical proximity to the courts, and the importance of local justice and local courthouses. That's particularly so in the district court, which deals almost exclusively with domestic violence cases. There was an article in yesterday's Irish Independent by Shane Phelan, which quoted statistics from the court service, and they're the only statistics that I've seen in relation to comparative figures between this year's domestic violence figures from the beginning of May to the beginning of July and last year. So we can see very clearly the influence of COVID-19 and the lockdown on them. And what it showed is that there's been a marked reduction in the application for some types of domestic violence relief, namely full safety order and full barring order, whereas there seems to be a big increase in temporary applications. But overall, the overall numbers of applications are down during COVID. I suppose that can be explained, in my view, for a number of reasons. One, the general time when domestic violence applications are at their height is not during Christmas, when perhaps the violence is being perpetrated, but after Christmas, when the children are back to school. And again, as most domestic violence, it seems to be perpetrated in households with children, not exclusively, but primarily in a lot of cases. Having children in the house is a big problem. And during lockdown, you couldn't get a childminder. It was quite difficult to get somebody in at all during most of the lockdown. So that may be one reason. So childcare may also be an access issue in terms of family law, but proximity to the courts, it wasn't that easy to travel on public transport. That applies in COVID and outside COVID. For the entire Dublin metropolitan area, the principal district court for childcare is Dolphin House, which is located in the centre of Dublin. Most buses can get into Dublin, but it can be quite a journey from the suburbs. And I wouldn't like to underestimate the factor of proximity from the courthouses. So however true that is in Dublin, it's doubly true outside Dublin, where there isn't any kind of level of public transport infrastructure available. So these are things that I hadn't considered myself previously in terms of access to justice. I would have thought more in terms of resources, more in terms of legal aid, but there are things that have been thrown up by COVID. Another barrier to people in family law accessing the courts, whether for domestic violence or other matters, was their perception of what the law was in relation to travel. And that also affected how they implemented their rights, or they sought their rights. It was only a number of weeks into the COVID-19 pandemic that the issue of access was clarified by the Minister for Justice, by the President of the District Court, by the Family Lawyers Association, and by the Law Society. And they were very welcome clarifications when they came. But it also was enshrined in the legislation, or the statutory instruments, which said that travel for access was permitted. But even though that was publicised, and even though it was the law, quite a number of people still didn't realise that they were entitled to travel. In my experience, a lot of those people were people who may be slightly vulnerable and didn't realise, or were dependent on other bodies which weren't in a position to advise them in relation to their right to travel during the lockdown. And I think access to good verifiable information is obviously a huge part of access to justice, and also people's perception, because there was quite a disconnect, as people are aware, between what the government was actually saying and what the law was in relation to travel and freedom and restrictions on travel. So I suppose COVID was the greatest restriction in my lifetime on freedom of movement, and quite a number of people were reluctant to leave the house or to get involved in travel, even though, had they read the legislation, they would have realised they could have travelled. But again, even most lawyers didn't read the legislation. So it's very important that the soft information is there as well as the hard information. I suppose other issues in terms of access to justice for family law clients is the people being trapped in houses where they can't, there's no means of accessing services, or communications were a lot more difficult during the lockdown. In terms of resources, the legal aid system is going to come under increasing pressure. It operates a free system for, a system where there was a contribution to domestic violence legal aid, but it's much easier to get legal aid for domestic violence related cases. However, access and maintenance cases suffered, and I suppose access to justice again was emphasised during COVID by the fact that priority was put on certain types of cases, and essentially access to justice in relation to other types of family law cases was denied or suspended for the period of COVID. Again, that's a microcosm of what happens in the general justice system. It's not formally stated that some cases are more important than others, but the way they're listed and the way the courts are treated and the length of time you wait for cases or for legal aid determines what the system thinks of you. And again, family law is regarded as very much the poor sister in that there's a lack of resources, there's a lack of funding for legal aid, and there isn't a great priority put on quite a number of cases. But during COVID, it became very obvious that the only cases that were going to get heard were the extremely acute ones, which were the applications for domestic violence. Cases apart from that, such as breach of maintenance, breach of access, were really put to the second tier until much further on into the COVID. Now, the President of the District Court addressed breaches of access, and they became urgent matters in the District Court only, but not in other courts. Breaches of maintenance also were upgraded much later on in COVID-19. But for the majority of the duration of the lockdown, it was difficult to get into court for those. And again, you could only get into court once these became urgent if you could prove they were urgent. So there was a further barrier during COVID-19 to that. In terms of virtual justice and whether that resolves or solves access to justice issues, I suppose the first point to note is that it's not appropriate for every case, but it is appropriate for some cases, particularly where there's no witness and there's no need for cross-examination. And if virtual courts can alleviate some of the queues for cases, if they can take some of the pressure off and they genuinely move matters on when they can't be done otherwise, then it's to be welcomed. But certainly in where cross-examination is required, it's very difficult to have faith in virtual courts. And again, because resources are so scarce, particularly in family law cases, it's very difficult to see how there is an actual saving to the court service and to the courts, because the court system is based around the importance of the judiciary and the court service rather than the needs of the litigants. So it's very much, and that's become very evident from the COVID-19 that is the first part. I mean, obviously the court service mandate is to serve the litigant as well, and that is a significant factor, but it is not the primary factor. And if you read the mission statement of the court service, you very quickly understand where they're coming from. Another barrier, as I would see it, to access to justice, particularly in family law matters, is the complexity or the lack of clear legislation, particularly in relation to as basic an act as the Guardianship of Infants Act 1964. It's very difficult to establish who is a parent. It's difficult to establish precisely what automatic guardianship means. It's quite difficult to understand who may apply to be a guardian. There are loads of different types of access, which are all welcome changes and innovations in many ways, but they're quite difficult to decipher, even for solicitors or barristers or lawyers, and sometimes even for judges. So I think certainly I would say the 1964 Guardianship of Infants Act as revised, and it can only be read as a revised statute in the Law Reform Commission's website. You can't read it in its basic form because it's been amended so much. The 2015 Family Law Children Act has changed it almost beyond recognition, but again, reading the 2015 Act won't assist you in deciphering the 1964 Act, because you have to literally put all the the amendments into it. So it's very difficult to understand some of the family law legislation, and particularly the Guardianship of Infants Act. That is a barrier to understanding what rights you may have and how you would enforce them. And that is a problem. Another problem is the cohabitation legislation, which was brought into effect on the 1st of January 2011. Most people are completely unaware that that legislation is in place and that they may qualify as a cohabitant, and they may have redress against the other cohabitant. So again, that, I think, public information, I think Eilis touched on this, that there's no point having laws that nobody knows about because they won't be enforced, and lawyers can't enforce these laws. The leading cohabitation case came about where the applicant wasn't aware that he was a cohabitant, but was in a solicitor's office and was told he was a cohabitant because he had an entirely different problem created by the parties in the cohabitation case, and it was pure luck. So those types of cases and the complexity of the legislation shows us that really we're not doing a good job. I also think the in-camera rule is a barrier to access to justice because people don't realise what's going on behind the closed doors. Family law isn't really reported that much on in the courts. It's not that people would have to be named or identified, but certainly there could be more. Certainly the childcare reporting project, and Carol Coulter has done fantastic work in that area, but we need, I suppose, more work by lawyers and by academics to explain precisely what happens in the courts, and also how people's lives are changed for the better by the results that they get in the courts. Finally, I was just going to talk about the lack of resources and the good news that we received, if indeed it is good news, that there is funding allocated for the new family law complex in Dublin in Hammond Lane. Currently, anyone doing childcare in the Bridewell, which is a 19th century criminal court complex, I suppose the 3 courts there, it's really, it's Dickensian is the best way to describe it. The acoustics are all wrong. It's not an appropriate place to have children. That is going to be replaced with a site which is just off Church Street on Hammond Lane. Allegedly, the money has been found now for it, and it will be built. I didn't think it would be built in my lifetime. I really hope it is built. I think it would be fantastic, and I think we need more ADR and collaborative law, and we need certainly a lot of other eyes on family law and to open it up much more. The last thing I'm going to say is just that there's a family courts bill which has been in justice for a number of years. Apparently it is also going to get published in the next number of weeks or months, and that's going to create a special family law division. But one of the downsides of it, which is I suppose why I'm concerned about local justice, is it's going to consolidate, particularly outside Dublin, the various courts, so that you'll have specialist family courts which are to be welcomed. But it does mean that people will have to travel very large distances to access those courts, and that may be okay in the divorce separation type cases, but in your more acute type need case, like domestic violence, like access, your more district court cases, I just would have concerns about whether that would be appropriate for all family laws. So I think there's going to be a lot of change to come. I hope it results in an increased access to justice, and I look forward to answering any questions. So thank you very much.
Thanks very much, Keith. Our final guest then is Wendy Lyon, who is an immigration and human rights solicitor, and she's a founding partner of Abbey Law, which is a boutique human rights law firm in Dublin.
I did unfortunately lose part of Eilis's talk, so I hope I'm not going to be covering anything that she already covered. I was able to hear her congratulate me on the Chilean student case. Thank you very much, Eilis, and that's actually quite a timely issue because the Chilean student, who, in case anybody hasn't heard about it, this is a young woman who came to Ireland with a permission to enroll in a English language course here. She had checked in advance with the Department of Foreign Affairs, with their consular service, as to whether she'd be allowed to enter. She was assured in absolutely unequivocal terms. I mean, honestly, as a lawyer, you dream of having evidence this strong, unequivocal terms that she would be allowed to enter. And then, of course, she was detained and put into Mountjoy for over a week. turn my phone off there.
Oh, yeah.
Okay, can you hear me now?
Yeah, perfect. Thanks.
Okay, great. She had no access to a solicitor during this time. She had a right to access a solicitor, although she wasn't necessarily told this, but she had no legal aid to access a solicitor. So in order to get somebody there, basically, I had to do it pro bono. Now, obviously, because of the fact that the case was won, there will be, some kind of agreement for the state to cover her fees. But if we hadn't been able to do that, then, obviously I would have had to do that pro bono. And lawyers are aware of these things at the time that they get the call or they get the email saying there's somebody in immigration detention. In a lot of cases, you're not actually going to ever be paid for that. And, it does affect access to justice, obviously. I had originally planned to talk about a couple of other things entirely. The first thing was legal aid in the immigration sphere, because it is absolutely dire. For the most part, there is no legal aid for immigration cases at all. The only situation in which you are entitled to legal aid is if you're making an application for international protection. And the legal aid that's available there is very, very poor, and it's so bad that it's really impossible to get proper representation as a legal aid client in the for an international protection application. So I'm just going to kind of set out exactly what goes into making an application, just so that I can then show you why it's so bad. If you're making an application for international, and this is just in case people don't know, international protection is like refugee status. So these are people that are possibly at serious risk of torture, murder in their native countries. You come to Ireland, to make an application for international protection, you go to the International Protection Office. Okay, so you have to do this personally. You fill out a form, you do a short interview. All of this is done without any legal aid whatsoever. You have no legal aid at this point. You're making an application. What you say is going to be recorded. It could be used against you in the course of your application. You have no legal aid for this process. It's only after you've made the application, once you have those forms that say that you have applied, that you can then go to the legal aid board, say that I need legal aid. You will be assigned a solicitor. Usually, it may be within the legal aid board itself, a solicitor within the legal aid board, or it may be farmed out to a private practitioner such as myself. At the point at which you get that solicitor, theoretically speaking, you should be able to do everything else after that with the aid of that solicitor. But in practice, because the rates are so poor, you probably are not going to get that much advice at that stage. So you'll be given this questionnaire to fill out. It's like an 84-page questionnaire. This questionnaire will follow you around for the rest of your life in Ireland. Like, I have had cases where somebody has been through the system, passed the system, got citizenship, and then a few years later, something happens which causes somebody in justice to go back, take a look at that questionnaire, and say, hey, wait a minute, and your entire life can unravel at that point. You obviously 100% need legal advice to properly fill out that questionnaire, and you're not necessarily going to get it because of the fact that, as far as the legal aid board is concerned, you're entitled really only to advice at that stage, not to actual assistance with doing the full application. After this, you have an interview. The interview takes place at the International Protection Office. It can range from anywhere from an hour to 4 hours to the whole day. Sometimes people are called back for a second interview. Clearly, this is a case where you would want to have your solicitor present, but guess what? That's not covered either. So you will have to be in there the whole time on your own. You can't even pay your legal aid solicitor privately. You can't even say to them, look, okay, I know this isn't covered by legal aid, but I could raise the money. I just want somebody there with me. No, as your legal aid solicitor, I am not allowed to take that money from you and sit there with it. That would be a violation of my terms of the legal aid board. So you basically, either you have to go to that whole interview on your own, or I have to do it unpaid. And I have done it unpaid, in cases where I felt, that the person is extremely vulnerable and where there's a big likelihood of risk. But, as a lawyer, you never want your client to be talking to anybody who has a possibility of affecting their case without you being present. And it's just not possible to do this in most cases. There's also recently been a case in the High Court where the applicant's solicitors looked for the notes that were taken of that interview and said that we should be entitled to see the transcript from that interview before a decision was made. And the High Court said, no, you're not. The reason being that the applicant was entitled to have, you could have gone and sat there with them for the interview. But again, if there's no legal aid for it, this is simply not going to happen. So you get your decision then, and then you can appeal the decision. You can appeal the international protection refuse if it's a refusal, and you will get legal aid for the notice of appeal, and you will get legal aid for the hearing. But again, the amount of legal aid that is given for that hearing is extremely low. You get the same amount no matter how many, say the hearing has to be adjourned for whatever reasons, you turn up and the interpreter isn't there and you have to come back another day. It's exactly the same. The hearing lasts for a little while and then something happens, it can't continue, you have to come back another day. There's no additional legal aid for that. This is obviously something that, it costs lawyers an awful lot in time to be doing, and the payment is very, very poor for it. And often also will want to have a barrister there to do it rather than have the solicitor do it, particularly if it's a case where there's complex issues that need particular advocacy skills. You have to split the payment that you get with the barrister. So that means you both get a very poor amount. And just another thing happened just yesterday in the immigration list in the High Court, where an application was made for it to bring leave to challenge a decision of the appeals tribunal, and an application was made for 2 counsel because the junior counsel who had attended, or the barrister who had attended at the tribunal hearing was very, very junior, and it was just felt, having sought further legal advice from more senior counsel, it was felt that it would it'd be in the interest of justice for the applicant to have a more experienced counsel assist with the High Court proceedings. And the judge was extremely reluctant to grant this because he said that he didn't want to encourage a situation where less qualified counsel were going to the appeals tribunals. But of course, with the rates of legal aid that they're paying, you're not going to get very senior counsel to go to the appeals tribunal hearings. It's a system that is built in to have devils and very newly qualified barristers tend to be the ones who get these appeals tribunal hearings because they're the only ones that are willing to work for that low amount of pay. Okay, so all this happens, you get refused on second stage, and then you have no more right to any further appeals after that, despite what you may have heard from a lot of opponents of the whole international protection system. It's not the case that you get appeal after appeal after appeal. You get one appeal and that's it. What you can do at that stage is you can make further representations as to your right to permission to remain. But again, there is no additional legal aid for this at all. So it's entirely a matter for whoever granted the legal aid certificate, was granted the legal aid certificate in the first place, as to whether they're even going to be willing to put in a lot of submissions at this stage. And unfortunately, a lot simply won't do it. So at that point, you're kind of just stuck with whatever you have. If you get a deportation order, you don't get legal aid to challenge the deportation order. You don't get legal aid to put in any additional sort of applications that may happen at that point, like say maybe in the interim you've married an Irish citizen or you've had an Irish citizen child. The way that the system is set up, you are supposed to make a separate application for that. You're not supposed to be allowed to include it in your general application for permission to remain, but there's no legal aid for that. So I mean, I've kind of had to run through this very quickly because it is a little bit complex, but I hope that people can kind of get a grasp of the sense of this, that the amount of legal aid that is available for these applications is so bad that it is simply impossible to do justice with the legal aid that's on offer. And what ends up happening is that either people do a lot of work for free, or some very good immigration lawyers just don't do legal aid work for international protection applicants because of the fact that they just feel that they cannot, conscientiously do it for what's on offer for it, and they will only do it for people who actually have the money to pay the private fees. And then you also have some solicitors who are, not really immigration lawyers at all, but there's a legal aid certificate available for it, And, they obviously think that they're doing the right thing. I'm not, I don't mean to be critical of anybody who is trying to help people in international protection cases, but, if it isn't your area of expertise, you aren't necessarily going to be doing them a lot of help. So this entire system is just, it's something that is absolutely crying out for reform. I've probably gone over my time at this point, but I do want to say a brief thing, another thing that Eilis had mentioned earlier about the High Court immigration list. And this is a list where anything that falls under immigration is dealt with separately from other types of High Court cases. So this would include asylum applications, EU treaty rights applications, visas, citizenship. It all goes into a different list. It's dealt with by a different judge, and different procedures apply. There's a particular piece of legislation, Section 5 of the Illegal Immigrants Trafficking Act, which is particularly draconian. It only affects some cases in that list. It affects deportation orders, refugee cases, applications under Section 4 of the Immigration Act. But what this does is it imposes a time limit of 4 weeks to make an application for judicial review after you get a decision. Now, 4 weeks may seem like a lot of time if you're, if you don't know really the way that it works, but this could require you to find a lawyer if you don't already have a lawyer, to find a new lawyer if you had a lawyer but they were covered by legal aid, and you can't get legal aid for High Court cases. It may require, may need that time to get documents translated. So 4 weeks really, it comes up very, very quickly. The most egregious thing about Section 5 is that if your High Court application is refused, if the judge rules against you, you can only appeal if that same judge says that you can appeal. Okay, you don't have the automatic right to appeal that you do in almost every other type of High Court proceeding. And every time I mention that, people's mouths fall open. They can't believe it, but it's true. There's also in that list a series of practice directions, which are, they don't have the force of statute, but they are essentially, you have to abide by them or your case is not going to be dealt with. They require extensive submissions to be made by the applicant solicitors, essentially, them barristers. Essentially, when you are making your initial application, you have to practically write the state's case for them. You have to say, this is all the reasons why my application shouldn't succeed, and then try to override that. Say, this is what they'll say as to why my application shouldn't succeed, and this is why they're wrong. You don't have to do that in any other situation. You have to get them to swear, your client has to swear an affidavit which states their religion. Okay, I think this is completely appalling. I think it's completely in breach of the European Convention on Human Rights. They have to actually say in their affidavit, I am a Muslim and this affidavit is being sworn on the Quran, or whatever. And then you as the solicitor have to also swear an affidavit to say, to my knowledge, this applicant is a Muslim and I have been present and have seen them swear their affidavit on the Quran. It's quite insulting to us as practitioners to be told that that we're not doing our jobs properly by letting our clients not swear their affidavits properly. There have been issues where for example, during the lockdown, I had a case where I had a client who was out in the west of the country, very, very vulnerable client, very ill, unable to travel to Dublin, and I couldn't actually get his application lodged because I couldn't be there in front of him to witness his affidavit, and I couldn't be there in front of him to say that I had seen him swear it on the Quran, and I couldn't find a solicitor in this part of the country who would go to all the trouble to do this for him. So his case was delayed for a few weeks, and it was actually a case where we were trying to get a very quick decision because he needed his status to access social welfare. So there's so much going on in that list, really, and it's just, it feels like it's one thing after another, and it feels like we're just constantly fighting this battle there just to try to get the same type of access to justice for our clients that ought to be available and that would be available in the ordinary judicial review list in cases that don't involve immigrant clients. It certainly feels like there's an element of discrimination there. And that's probably, I probably could go on for another hour about this, but I suppose I'll leave it at that.
That's great. Thanks very much, Wendy, for those eye-opening remarks. So the first question, just for all of the panelists, is what are your thoughts on what the long-term effects of the pandemic will be to access to justice? Is it merely that it will narrow access, or does it present opportunities in the widening of access to justice at all?
Andrew, I can give a form of an answer to that if you like.
Perfect.
I think, first of all, I think access to justice is linked to the economic conditions out there, and I think we haven't reached it yet, but we're about to fall over a cliff. So I do, unfortunately, I'd be very concerned about access to justice in a post-pandemic world once we get over the health issues and then we start looking at that. So I think there's that. I think apart from that, I would see huge potential efficiencies having been developed in terms of virtual courts and administration of the court service. I think it has been a time for consideration. I think that we need to look again at the court service and the priority of the court service. My own view is the court service, it needs to perhaps serve the litigant more than the system a little bit, and we need to look at how that's done. So I think there's a lot of food for thought in it, and I'm sure there's many other points that other speakers want to say, but there are two that jump out at me, I suppose.
Thanks, Keith. Jane, I suppose in terms of criminal law, what are your thoughts? I mean, as Keith said, there is the link with economics and law, and as we would see in the criminal courts, there's links between housing and mental health and health generally. And the criminal courts. So I wonder what your thoughts are.
Yeah, absolutely. I suppose one of the biggest things that we've seen throughout the COVID-19, particularly in sentencing hearings and in some bail applications, is the lack of outside resources that some NGOs or drug rehabilitation centres or Peter McVerry might otherwise would have been in a position to provide. So those letters of referral, those support systems, those detox programs, they have unfortunately, I suppose, been suspended, and that has been in some way a bit of a barrier for people who otherwise would have had the best of intentions to better themselves or put themselves in a better possession for their bail apps or for their sentences. With regard to the general court system, I know from speaking with a number of guards and sergeants who I would prosecute with, they didn't see a decline in crime during the pandemic, despite lockdown, and perhaps we thought we were all battening down the hatches. I think Keith has already indicated that there was a significant increase in domestic violence and some serious crimes, serious drug crimes, violent crimes, rape crimes, and sexual assaults. Most of those have gone off for directions to the DPP. So perhaps the media haven't quite realised that, in fact, the statistics aren't necessarily reflecting the arrests at the moment. It's just a delayed matter. So we expect some significant matters to come down, I'd say, for trial towards the end of 2021. I think we're looking at now for new trial dates, 2021, 2022.
And with that disclosures crisis that you mentioned in the UK, is there any reason to be concerned that a similar systematic failure might occur here in Ireland?
Absolutely. I think it was best described to me by a judicial colleague who I won't name now that we're being recorded, but that we're effectively on cruise control, driving on an icy road with our eyes closed and the engine light blinking. So we're really just waiting for the shoe to drop. It's foolish of us to think that we would somehow be immune to these matters when England have fallen foul of them, America has, Australia had to a smaller degree, but they certainly had their own issues. As trials become more complex, as social media features more heavily, mobile phone records, then generally financial records are coming more in the fore. the amount of information that is disclosed can run to anywhere to 20 to 50 bankers' boxes in some cases. And that data is generally given to practitioners on liquid files or remotely. So it's very difficult for lawyers to be in a position to sift through everything and to be in a position to pick out relevant bits. And that's not a slight on Garda Síochána. They're obliged to give over every piece of evidence that's either inculpatory or exculpatory. But sometimes it's a deep dive and things are missed. And that also can go on the other side of the fence with the prosecution, where they may miss disclosing something. And that really was the difficulty in England with particular rape trials, where mobile phone evidence had been a little bit buried and it didn't appear to be malafides. It was just an overwhelming amount of information and a misstep. But I think, as all the other practitioners have said, and it's probably not the most favourable topic to say, funding is necessary, I think, across all of the court system. And unless you have the administrative staff and the support staff in the guards, the prosecution, or in defence solicitors firms who have the time and the capacity to give the attention that's necessary in these matters, you're going to have a system that fails. And it's not going to be popular. Nobody likes putting on the poor mouth or saying anything, particularly in this climate, but we're going to see, I think, problems happening, and we're not in a position to fix them at this point. So batten down the hatches, folks.
And you would have seen in England with the Lord Chancellor, with not the abolition of the jury trial, but certainly that extension of non-jury courts. And I was reminded of the line in The History Boys, where there's a former history teacher becomes minister in it, and it was quoted by Mr. Justice Hardiman in an article he wrote, which is that they're trying to abolish the jury, and they say, paradox is good, that you can say the loss of liberty is the price of freedom. And that is sort of the vibe that I'm getting, like, certainly with the kind of words used by the Lord Chancellor there. And I know that Scotland was also considering that extension of non-jury courts. Should we be concerned about the jury, both in Ireland and internationally? Is the jury trial an endangered species?
Well, I know Mr. Gerard Hogan had spoke somewhat on this through the Brexit remarks, and that now we're the only common law system left in Europe, and we really are the last ones fighting for this adversarial system, and by proxy the jury system. I'm a purist at heart. I can't imagine a world where the jury system, where you're adjudicated by your peers and not by lofty lawyers with notions and privilege, are judging other individuals in respective matters, and that extends to the judiciary as well. I think we'll be able to preserve ourselves, but I think it's inevitable that certain matters will be diluted. Probably the first things to go will be the jury civil trials, albeit I know that they're not used to great extent. And then perhaps we may see more minor, low level, maybe serious matters start to be prosecuted on the cheap, so to speak, in the district court. And that'll start to be, I think, the dilution of the jury trial, that maybe certain matters just won't go forward for jury trial. But I'm not sure we're quite at the point where we're going to abolish it. And it was a little bit rocky for a while, where certain academics, and very well respected academics, were canvassing for smaller jury pools or the emergency times measures where we might forego them. But thankfully, I think we've weathered that out, and we're good to go now. The good thing to say as well, just on that note, is jury trials are back in motion on a very low-scaled measure from next Monday, this coming Monday. They're almost pilot trials to see if we can social distance properly, if we can have witnesses in court. And they're significant trials. It's a rape and another murder, I believe, is going on in the other court. So at least we're trying, and we're still holding on to the jury system as best we can.
All right, thanks, Jane. Next question is just for Eilis. Something that touched off just there by Jane is, the lawyer is obviously very privileged in society. And there was, in the new programme for government, not for lawyers, but for Garda Síochána, there was a promise that they would try to increase the diversity of Garda Síochána, the different kinds of people. And I recently seen Abbey Point talking on that, and the issues with travellers who have tried to enter Garda Síochána but were facing difficulty. I've noted that FLAC has announced the launch of a new dedicated traveller legal service. So could you just tell us about what obstacles Mincare face in accessing justice and how FLAC is trying to address them? Sorry, you're on mute, Eilis.
Sorry, Andrew, if I could just respond to your last question as well. I mean, you know, in FLAC's view, access to the courts is fundamental to access to justice, and we desperately need a functioning, accessible court system. And I think the weaknesses in the court system have been shown up by COVID, and the reality is the court services haven't been funded, and they have to be treated as fundamental to the administration of justice, and to date they really haven't. So you know, while there may be, you know, some people are welcoming moves towards online courts, we would welcome that in some respects, but again, that would have particular problems for people who wouldn't be necessarily have access to online facilities, and people with particular vulnerabilities it mightn't suit as well. So it goes back, it is a question of resources and how the court services need to be resourced and resourced very quickly. But going back to your question, we're delighted that Christopher McCann has been appointed as a solicitor in our new dedicated traveller legal services, which has been funded by the Community Foundation of Ireland. And the traveller community suffered the greatest discrimination in Ireland. There was a ESRI report in 2017 which showed that up, and FLAC for some time has been providing representation in a small number of cases, but they experience huge barriers in terms of access to justice. I mentioned earlier, there's no legal aid for discrimination claims, and there's a perception that there's no legal aid for housing claims. And housing and discrimination to date have been the issues that FLAC have had to try and address. So we're delighted that we're having this dedicated service. There's just one solicitor employed, so there's limited resources, but he will be trying to bring cases that will have an impact beyond the individual. And there's so many issues, it's been necessary. We have a steering group made up of traveller NGOs who have to agree the criteria in terms of the cases that will be taken, and we'll be focusing on issues like access to accommodation, the failure to implement traveller accommodation programmes, the failure of local authorities to draw down the funding that's there to provide accommodation. We'll also be looking at difficulties travellers may have in being designated as homeless and therefore not entitled to emergency accommodation. And we'll also be looking at issues such as discriminatory practices. There's been complaints about how travellers in schools, or some travellers may be required to have a reduced timetable. So we'll also be looking hopefully at the criminal trespass legislation, which effectively criminalises the way of life of travellers. So there's loads and loads of issues. I can see that there's a danger we may be overwhelmed, but I'm hoping we won't, and that we will make efficient use of the resources that we're getting, and we're really happy to be getting that resource.
We have a question here, which is that the new government in the Programme for Government promised to make a policy for undocumented within 18 months. My question is whether there is any updates in that regard and who could be beneficiaries of this policy.
The short answer to your first question is no, there's no updates. I get asked this question all the time and literally have no idea, have absolutely no idea what it's going to look like, who's going to be able to benefit. It's all just a matter of seeing what happens. If I could just say something as well on the last question about the COVID opportunities. One thing that I had kind of hoped would happen as a result of all of this would be that there might be more ability to do e-filing in the courts. That has not happened at all. In fact, it's become more difficult to do any filing, at least for the High Court. It's actually become a very serious problem, just trying to get the papers filed in the High Court these days. So that's also having a big impact on access to justice.
Also, Wendy, just last September, the Ombudsman called for his remit to be extended to include complaints about the asylum process itself. Mm-hmm. Do you think that has any tangible benefit or would have any tangible benefit for asylum seekers?
Absolutely. I mean, I think it's always the more the more the ombudsman can cover, the better. And we've certainly seen other situations in which the ombudsman's involvement in matters has had a real intangible difference. And just my own experience as a lawyer would be around the Magdalene laundry cases, where basically the ombudsman was responsible for getting a whole cohort of women admitted into the redress scheme who would have been excluded otherwise. The ombudsman does have limited powers. The power only of recommendation rather than, they can't force government bodies to do anything, but there certainly is a strong amount of influence there. So yeah, I would absolutely welcome that.
And just another question, because you're a qualified attorney in the US, I'd like to hear your views of the proposition for a review of maybe a public defender system in Ireland. What would be your
I'm with Jane on this. A complete disaster. Absolutely, absolute disaster. Don't even go there. It's the whole system in the US is entirely underfunded. There's no reason to think that it would be any different here. You have a situation where, if you look at the statistics, and I haven't seen any recent statistics, but I know, I doubt they've changed that much from the last time I did see them. If you look at the statistics of people who are on death row in the US, apart from race and the other things that you might expect to see, the overwhelming thing that they have in common, people on death row, are people who could not afford their own lawyer and had to go for a public defender. It's just the gulf in the quality of legal assistance that you get there is huge, and I just wouldn't want to see that come in here at all. At least here, like most, the legal aid criminal lawyers are the people who are down there every day. They are the experts. If I was facing a criminal trial, I would want a criminal legal aid lawyer because I would know that they were there all the time and they would know what they were doing. That's not, I don't think you're going to be getting a better quality of legal advice by bringing a public defender system at all.
Thanks, Wendy. Keith, with the announcement of the Hammond Lane project, obviously that's to be welcomed if that is carried through. Just could you give us some information as to the facilities for family law courts outside Dublin, and what's that like, and how could those facilities be improved? And I suppose part of that will be maybe a discussion of whether or not those specialist courts actually are brought about.
The courts outside Dublin operate on a kind of one big court in the county town in most cases. So you have a big courthouse, we'll say, in Galway City, which would serve most of Galway, and where the circuit court would sit. And if the High Court was down there, it might sit there. And there would also be a district court, usually attached somewhere around. That's very similar, we'll say, in Naas. So what you have is one very impressive, huge courthouse with probably 2 courts and the combined court offices. And you currently, again, I suppose family law is done mainly in the circuit court for divorce and separation or marital cases, in the High Court for child abduction and big money divorces, and then in the district court for all non-marital child-related matters and childcare cases. So the district court would sit most days generally, but it would only do family law on certain days, and certain days would be childcare in the district. Depending on the district court, you may have other lists going on in between, before, afterwards. So you could have maybe a criminal list in the afternoon, and it could be technically separate from the family law cases, but in actual fact they all get jumbled in together because cases overrun. And there's no privacy whatsoever outside Dublin, so if you're in an in-camera matter, it doesn't really matter because people will see you down there, hanging around the court precincts, and it's very easy, even in Naas, which is the one I suppose outside Dublin I'd be most familiar with. It's quite easy to see who's in the court just by driving down the street or walking past the courthouse, because people are in or out. And it's even worse in COVID-19, unfortunately, because people are being forced, in Dublin in particular, to stand outside the physical courthouses, and particularly the circuit court. I suppose it's fairly haphazard. It'll depend on the local judge for the district courts. You kind of follow the judge around, so if you miss them, you may have to catch them if they're in another district court, because as you know, district court judges on particular districts may, for example, the district court judge in Mayo would maybe travel around Castlebar, Ballina, a number of different district courts. They just wouldn't have one place where they'd sit. So outside Dublin, you have we'll say bigger counties like Galway, Kerry, Cork, all of those, you'd have a district court judge who would travel around a number of venues and would have particular days. So some days might be criminal, some might be civil, and some might be family, or they may all be jumbled in together in their list, depending on how the judge tries to do it. So one of the issues is that the president of the district court has no control whatsoever over the district court judges. So the president can tell the district court or ask the district court judge to do things in a certain way, but if they don't do them that way, there's zero recourse. The district court judge is appointed to a district. Certainly the circuit court judge was appointed to districts, I think, by the government. It's a whole issue about the control of the presidents of the jurisdictions. So there needs to be more control by the president of the circuit and the district, and to a lesser degree the High Court, on the judges, so that there can be a uniform approach. So the huge difficulty, I suppose, isn't as much the physical infrastructure as the huge lack of any kind of consistency in family law. Family law isn't in the newspaper, so different judges can't even see, like personal injuries, what the level of damages for certain awards are. It's rarely reported. It's extremely rare to see any report of a family law case outside the High Court. And again, they're only big money cases and they don't really apply to circuit or district court. So I think the lack of consistency is one of the biggest problems. I think a reform of the court structures to have specialist courts is good in some way, but in other ways you're going to lose the local justice. And I mean, particularly if you have a barring order, we'll say, and you're in Kilkelly or Ballyhollis and Mayo, and your nearest district court, even now, is probably Castlebar, which is a bit away. If that moves, probably as it's likely to do, I suspect, under the new system, to Sligo or to Galway, you're talking a much greater physical journey. And I think during COVID, it's not just the physical journey, it's the rest of your life that you have to organise to permit you to leave whatever you need to leave at 9 o'clock. And that's fine, we'll say, if it's children and the schools are on. But again, if you're working or other things. So there's a whole infrastructure and a way we do courts that suits the judges and suits the judiciary, and to a lesser degree, but still suits the lawyers and the call-overs and all of that. And I think we may have to look at how we do justice differently. And just touching on the access to the legal professions point, one of the innovations the Law Society has brought in as a result of the Legal Services Regulatory Authority pressures, but as a result of responding to them, is that there's now evening courses for trainee solicitors, so that you can attend Blackall at night. I personally was a huge fan of the BL course that King's Inn ran when it started at 4:30, because it brought a whole different cadre of people. Maybe not as diverse as it should be, but it certainly opened it up a little bit, and it's a good first step. I think we may need to look at maybe having a domestic violence court sitting later in the evening or at different times. I mean, 10:30 to come into the centre of Dublin, I'm not sure. And I think the other difficulty is transport outside Dublin to get to the courts. However bad it is in Dublin, and it's not great, it is much worse outside Dublin to try and secure transport. And again, these are the most vulnerable people who don't have access to a car, or you may have a family, because I'm talking about family law. You have one family car. I've heard many instances of many cases about who gets to use the family car and the control over it, unfortunately, which leads me to believe that the person who might need to get the barring order, or to get the relief from the court, isn't the person who has access to the keys to the car. Or there may be a car, but they're not allowed to use it. You know, taxis in local areas, really, people know each other's business and stuff. It's actually, it shouldn't be a problem for access to justice, but I think it is a problem. So I think it is problematic, but at least there will be some proposal to resolve it. And I think we all need to get in there, FLAC and the Law Society and family lawyers and stakeholders like One Family and Tror, and say, look, you're proposing it this way, these are the problems, but let's come up with solutions. And I think we can't afford to let the current family law system continue as it is, because it isn't working for anyone at the minute, I don't think. So again, I don't want to make it worse, but I think we're going to have an opportunity to have a good policy debate on what should happen. But unfortunately, we're probably doing it at the worst possible time, because I cannot see a worse time in terms of allocation of resources in the longer term to salaries of people in courts, to the maintaining of courts, and to the creation of additional resources what we're talking about with any new system is we need additional resources. We need more mediators. We need more Section 47 assessors. We need more legal aid. And there is, even in the statement, I think, that was made by the court service at the recent webinar, there's a commitment to change, but not to more resources, which in my view is, you can't do one without the other.
And as a mediator, with that commitment to change in the programme for government to encourage mediation, what do you think can be done in tangible steps to encourage mediation?
Well, first of all, there isn't a mediation council set up. The government have resigned from even setting that up. That's a kind of a necessary prerequisite to mediation be taken any way seriously. That means that if there's a complaint against a mediator, there's an independent body who can deal with the complaint. So that's a really fundamental process issue that the government has backed out of. What they've said instead is that you can set up a limited company between the various mediation bodies, and that mediation body can then take on the regulation. It seems daft to me. My view is that even a regulator could be self-funding based on the registration fee, and there's a way around that. So that's, if you like, a process mediation argument. I won't go any further, but that in itself is an obstacle, unfortunately. You then secondly have more information needs to be given out about mediation. There needs to be more, I suppose, more involvement by the legal profession and by the litigants in mediation where possible. I think there has been an increase in mediation since the Act came in. There's now a much greater duty on family law solicitors to provide information, and they have to swear a statutory declaration that they've done so, which again, it's an offence to not be 100% correct in those statutory declarations. So there's a much higher bar at the minute. And I do think there's a recognition in family lawyers in the past 2 or 3 years that mediation does work. It is an alternative, but I suppose family lawyers deal with the 1 or 2% of the extremely acute cases where it's gone really far. And it's a bit like maybe if someone's unwell, if you don't get things sorted right until the end, you know, there has to be a fairly radical intervention, and that's quite often what happens. So I wouldn't rule out the difficulties in cases that come to court that they're incredibly polarized by the time they even get to lawyers. And in a huge number of cases that I'm seeing at the minute, which are the more difficult end of them, people have been through mediation. In some cases it's worked for something, but not for others. And so I think we're going to see there's maybe a kind of suite of options, one of which mediation may resolve part, but not all. It may resolve all of it. The court may resolve one or part of it, but mediation could do something else. ADR might do some more, and collaborative law might do another element. I'm involved with the Family Lawyers Association in looking at arbitration as a potential means of resolving discrete issues within family law cases. And the advantage of arbitration is that you have a mediator is not involved in fairness. They're not going to decide what's fair or just in the circumstances. They simply want to get an agreement. So there's no element of justice in it, whereas an arbitrator has a different role and they're much more directive, which sometimes is what people want. They say, well, look, I've come to the end of my tether. We can't agree. We want a solution imposed on us. Now, again, that is not the starting point. That's really the end point that you get to, and that's when everything else is run out. But I do think we have to look at arbitration as a potential way of resolving things outside court as well. And I think the COVID-19 thing has taught us that if we can resolve cases, now is the time to do it, because the court space is not available. But notwithstanding that, there's still a huge percentage of my cases and most family lawyer cases where we've said to people, we won't settle it for another 6 months or a year unless you get together. No. So that's with the best will in the world trying to do it. So I think we've realized there are a rump of cases that are just exceptionally difficult to deal with without a judge who's going to or a third party.
Great, thanks, Keith. Maybe just for Eilis as well, I'd be interested to hear your views and the views within FLAC on mediation and the role of mediation, if you could. Sorry, I think you're still muted.
We would have made a submission to the Workplace Relations Commission because they issued a discussion document on their response to COVID-19, and what was very clear was that priority was going to be given to mediation, and that people who had been offered mediation would be, and who had refused it, would be re-offered it. And I have to say, we had some concerns about that, because we believed, in terms of the Workplace Relations Commission, that its primary function was to adjudicate on disputes, on employment claims or equality claims, and that to keep presenting mediation as an offer, we didn't feel was kind of recognising that mediation is supposed to be a voluntary process, and that if it isn't voluntary, it's not going to work. So I suppose we have some concerns that there is an overemphasis on mediation. We believe, and we argued to the WRC that what they should be trying to do was to try and have hearings at social distancing as soon as possible, and that we failed to see how mediation of straightforward claims, how if it was such a straightforward claim, well, then it shouldn't take up that much resources from the Workplace Commission. So I suppose we would always have concerns. As Keith was saying, it's the job of the mediator to reach a solution, to help the parties reach a solution, and very often the dominant party might remain the dominant party in terms of the solution that's reached. And in a lot of instances, if there is a straightforward claim, we would prefer that would be adjudicated on and adjudicated on quickly.
Perfect. Thank you very much. The next question is for Wendy. I remember seeing, I think maybe back in 2015, a panel in Buzzwells that you were sitting on with, among others, Kate McGrew of the Sex Workers Alliance, and you were discussing the prostitution and what then became the 2017 Act. That's now undergoing, as was contained in the Act, a 3-year review. So I'm interested to hear your thoughts on the performance of that Act, and also your thoughts on that review, because I understand that it is accepting submissions from all different kinds of groups.
Yeah, the review is basically just getting underway, and they've said that they will accept submissions from everybody, which is good. As far as I'm concerned, the law has done exactly what we said it would do, which is absolutely nothing to reduce the number of people involved in sex work, or the number of people trafficked. What it has done instead is created a much more dangerous environment for people involved in sex work. It's made sex workers have it's absolutely devastated relationships with Gardaí. Not that they were great to begin with, but they're far worse now. It has created a situation where clients essentially have a greater balance of power because of the fact that they can, they feel that they're the ones assuming the risk now. So they feel that they have, they can insist, they can demand greater service, more services than they would have been given otherwise. They can insist that women work alone when they might prefer not to work alone. There's absolutely no evidence in any jurisdiction where this has been brought in that it has done anything other than harm conditions for people in the sex industry. And Ireland is, I'm not at all surprised that Ireland is the same.
Great, thanks for your thoughts. So I'd like just to invite all attendees, thank you all for tuning in, and you'll all automatically receive at the end of this a post-webinar survey. So I'd encourage you all to complete that if you could. Thank you all very much. And a special thank you to Eilis, Keith, Wendy and Jane. Thanks very much for all of your very insightful remarks. And just for everyone watching, a full report will appear on this webinar in the Irish Legal News newsletter this Friday. Thank you all for attending.